DWI, also known as DUI or OWI in Louisiana, is almost epidemic. You can get a DWI while driving an automobile or, in South Louisiana, driving a boat. Operating a vehicle with a blood alcohol level of 0.08 or above, or if you're under 21 years of age, 0.02 or above, is a crime in this state. Many times you are pulled over for a check because your tail light is busted, you fail to signal that you are moving from one lane to another, and a police officer sees it and takes any small thing and uses that as reasonable cause to pull you over for DWI. What should you do? Number one, if you blow in the machine, the intoxilizer, and you register 0.08 or 0.02 if you're under 21 years of age, that is proof that you are operating while impaired. If you refuse to take the test, they would have to prove by another means that you were operating while impaired. Your eyes were glassy, your speech was slurred, you were staggering or reeling or waving on your feet while you were being questioned by the police officer at the scene. But it is better if they don't have that solid evidence that you were 0.08 or above. They will take you to the police station for sure if you refuse a test, and they will probably take you if you take the test and run 0.08 or above. So should you take it or not take it is dependent. If you think you can pass it, and most people do, and they can't, take it. But you should not take the test as a general rule, because you will then be definitely DWI if you run 0.08 or above. If you don't take the test, you will have some other ramifications. Either way, take the test or don't take the test. If you are given a DWI, you have 15 days to apply for an administrative hearing. There are two variables to DWI. One is the criminal element under Title 14 of the Louisiana Criminal Code, and the other is the administrative driving portion of your rights. If you are driving a vehicle in Louisiana and have been issued a driver's license, you have consented to take the test. If you refuse, you will have an administrative hearing if you request it within 15 days to determine whether or not your license will be suspended. That is different from the criminal portion of the law. So you need to always request an administrative hearing. You probably should see an attorney to determine how to do that, who to subpoena to that hearing, and how to subpoena them. So DWI has two facets: criminal, administrative. One deals with your driving rights, one is the criminal, for which you could pay a fine, be sentenced to jail, be sentenced to community service. So before you do anything, once you receive a DWI, you should contact an attorney immediately to determine A, did the police have probable cause, B, did you refuse a test, and C, how are you going to deal with it in the criminal courts. You also need to address your driving privileges and whether or not you can keep your driving privileges, because if you get a DWI, you automatically lose them, temporarily at least. So whatever you do, if you get a DWI, OWI, or DUI, see an attorney. See an attorney with experience in that area. We at Hike, Menville, and Grubbs have that experience.